Good morning, everybody. I noticed that it is 9 o'clock. I'm not sure if we are waiting for more participants, but you've all joined in on time, so I don't want to keep you. My name is Jenny Dowlath, and I'm the Senior HR Consultant at HR Talk. I'm pleased that you joined us for this webinar this morning. As you know, the topic that we're going to discuss this morning is harassment in the workplace. I switched my video on briefly so that you could get a sense of who is actually doing the presentation, but I prefer switching it off if that's okay. All right, so let's get straight into it. The Employment Equity Act was developed to promote equal opportunity and fair treatment in employment through the elimination of unfair discrimination. So Section 54 of the Act empowers the Minister of Labour and Employment to issue codes of good practice, which gives us, as employers and employees, advice from the Employment Equity Commission. The Code of Good Practice on the Prevention and Elimination of Harassment in the Workplace was issued on the 18th of March, 2022, and it replaces a code that we're probably more familiar with, which was the Code of Good Practice on Sexual Harassment. Now, as you know, that at that particular time, the only type of harassment sort of legitimately viewed in the workplace was sexual harassment. That doesn't mean that if there was any other type of harassment that was made known to the employer, that nothing could be done. Of course, what this means is that there is now a code that guides what we do and guides how we do it. So let's focus on Section 6.1. It states no person may unfairly discriminate directly or indirectly against an employee in any employment policy or practice on one or more grounds, including the following. So there's a whole host of possible discriminatory factors that the Act actually stipulates. And some of these, I think we're quite familiar with these, including race, gender, sex, disability, HIV status. So these are all things that are not unfamiliar to us, but it's just been more explicitly called out in the Act itself. If we look at Section 6.3 of the Act, it states that harassment of an employee is a form of unfair discrimination and is prohibited on anyone or a combination of grounds of unfair discrimination listed in Section 6.1 of the Employment Act. So remember that list of possible infringements like race, gender, sex, HIV status, etc. So it could be one of those or a combination of these. Now, I think we know that, in most cases, when it comes to labor legislation, one act doesn't necessarily, work by itself. It is sort of supported through other acts, and other statutes that impact harassment include the Constitutional Right to Fair Labor Practices, the Promotion of Equality and Prevention of Unfair Discrimination Act, which is shortly known as PDUPA, the Labor Relations Act, of course, the Occupational Health Act, the Protected Disclosures Act, and the Protection from Harassment Act. And what you'll find that if you look at the code itself, so there is a gazette that is out. It actually gives you a brief description of what each of these statutes are, and then you can actually easily see how these integrate with the Employment Equity Act. What's important for us to understand is who an employee is, right? So when it comes to previously how we used to define an employee, it was the term that we all kind of, generically knew or understood, which is if you work for an organization, you are part of their workforce, you get paid through their payroll, you are an employee. However, that definition of an employee has changed, which now says any reference to employee includes applicants for employment and volunteers who assist in any manner in carrying out or conducting the business of the employer. I know at the beginning of the session, Charlene did mention that we will take we will take questions at the end of the session. So if you have any questions, please feel free to pop it in the chat function and I will address them at the end of the session. Equally as important is, once you understand who an employee is, it is equally important to understand who the victim is, or how do we define who is a victim. The code applies to a working environment as a guide to employers and employees, but perpetrators and victims can include, but are not limited to, So owners of a business, employers, managers, supervisors, employees, like we said, job seekers and job applicants, persons in training, including interns, apprentices, and persons on learnerships, volunteers, clients and customers, suppliers, contractors, or anybody else having any interaction with a business. So as you can see that the definition of victim is quite a broad range of different individuals and is not restricted to just the employer and the employee. What we also need to then further understand is where are employees actually protected from harassment? Now, if we understood how the code on sexual harassment played out, it generally was a case of, like we said, if there was a case of a sexual harassment allegation brought against a particular individual, it was based on whether those two individuals worked for the same organization. However, the new code actually says any situation in which the employee is working or which is related to their work. This includes, but is not limited to, the workplace, both public and private spaces in which people perform their work, places where people are paid, take rest breaks or meal, or use sanitary, washing or changing, breastfeeding or medical facilities. So as you can see that the areas in which possible harassment can take place is far bigger, and you have a bigger pool in which you can say, listen, I have an allegation of harassment. This is where it actually took place. So we've got to bear that at the back of our mind when we're understanding if an allegation comes through from an employee, where did it take place and how did it take place? Work-related trips, traveling, training, events or social activities, work-related communication. I think, in this day and age, with the type of technology that we have, most organizations have WhatsApp groups. And that therefore means that, people have access to other employees' contact numbers. So harassment can take place via technological platforms. So we've got to be mindful of that as well. Employer-provided accommodation, work transport, the location where the person works, if that place is not the employer's premises. So like if you're working virtually, etc. We now look at what is the definition of harassment. And I think, the code is quite explicit. And what I find interesting is just the extent to which harassment has been explicitly spelled out in the Act itself. It says it's unwanted conduct which impairs dignity. And if you think of any of the grounds for harassment, you can understand how those statements actually fit in with its unwanted conduct. It creates a hostile or intimidating work environment for one or more employees, or is calculated to or has the effect of inducing submission by actual or threatened adverse consequences, and is related to one or more grounds in respect of which discrimination is prohibited as per Section 6.1. Remember, Section 6.1 was the list of different types of harassment: racial, gender, ethnicity, HIV status, etc. It also includes violence, physical, psychological, emotional, sexual, gender-based, and racial abuse. As you can see, like I mentioned, we can see that it's quite a broad definition of harassment, but the code explicitly states all of these. It's physical force or power, whether threatened or actual, against another person or persons. So the code actually goes into defining what unwanted behavior is, because I think, if we all had to be asked, in your definition, Jenny, what is unwanted conduct? But if you had to ask Charlene as an example, Charlene may have a different interpretation of it. What the Act does do is give you a definition as it relates to the Employment Equity Act. So let's look at how we define unwanted conduct. One way in which we test if it was unwanted is, did the complainant communicate to the perpetrator that the behavior was unwanted? This can be verbal or non-verbal, directly or indirectly. If there was no communication, you need to determine whether the conduct was of such a nature that the perpetrator knew or should have known it was unacceptable. Now, in a place of work, we would assume that we're all adults and that we understand these things. But one of the reasons why we have this in place is because we've obviously at a point in time had seen an increase in the number of harassment cases that was coming through. So even though we say we should have known that it was acceptable or not, we know that there are instances where we actually, as adults, are unable to differentiate, is this particular behavior acceptable or unacceptable? Whether or not conduct constitutes harassment should be assessed on the objective basis from the perspective of the employee who alleges harassment, right? So it's quite important that, there's currently a matter sitting that is going to go through the labor court where a teacher she alleged sexual harassment against the vice principal of the school. And when it went to the CCMA, the commissioner actually ruled in favor of the school. However, the employee who raised the harassment case or the harassment allegation against the vice principal was obviously not happy with this. So the matter has been set forward for the labor court. It's going to be interesting how this plays out because in this matter, the number one, the perpetrator was not suspended from duty, so continued in his capacity as a vice principal. The employee, the teacher who raised the allegation, obviously actually reported to this principal. So, when we look about a hostile environment, and we'll come to the definition, it was a place of work where she was not comfortable. She had indicated that the behavior was unacceptable. She indicated both to the principal and to the vice principal that she's uncomfortable with the behavior, but the school did not take any action to suspend the vice principal. So we've got to be sure that, and understand, like the statement says, that it's assessed on the perspective of the employee. And the reasonable person still applies though, right? So as much as we have legislation in place, what we need to bear in mind and understand is that legislation is there to guide us, okay? But we have to apply our minds as well. Not outside, that actually is in contravention or contradiction of what the Act says though. Equally important to understand is that harassment can be a single instance, okay? So you don't have to wait for it to be progressive. So if someone is feeling bullied or harassed or whatever the case may be, any type of harassment, it doesn't have to be a progressive, it happened on this one day and then we had a break and then, 2 months later, the same thing happened. And then only on the third occasion did we feel a need to do something. A single instance or event or repeated events is regarded as harassment. And like I mentioned, bullying, for example, can be an escalating process where the complainant ends up in an inferior position and becomes a target of systematic negative social acts. The sad thing, and I think we're seeing an increase of this in a number of, not just in schools, but even in workplaces, that bullying happens. And sometimes, obviously the person being bullied has such a sense of lack of confidence and is so affected by that the person may not bring it forward. And so what happens is that the person who is doing the bullying continues to do so because he or she thinks it's acceptable because the person being bullied hasn't said anything and there's been no consequences. So we assume that it's actually acceptable. Excuse me. The following may be relevant to the issue of whether harassment has occurred. So what was the context of the harassment? The circumstances of complainant and impact the conduct has had on him or her, the respective positions of the harasser and the complainant. Remember, I spoke about a hostile work environment. The Gazette goes into actually defining what a hostile work environment, and it reads it as such. Conduct has a negative impact on employees' ability to work and or on their personal well-being. They may also be present where an employer should anticipate that employees will be subject to abusive conduct related to a prohibited ground by members of the public, customers, or clients, and fails to take reasonable steps to protect employees. And the point of the Act as well is that, and unfortunately or fortunately, however you choose to see it, is that it does put an onerous and a really big responsibility on the employer, because we are saying, or the Act is saying that, you know, as an employer, you need to put these measures in place. And we'll get into a little detail about this later. So how do we define physical harassment? It can be physical attacks, simulated or threatened violence or gestures, verbal bullying. It can be threats, shaming, hostile teasing, racist, sexist, or LGBTQIA+ phobic language. Psychological harassment looks at emotional abuse of the person being harassed. You know, when I think about the definitions of some of these instances, is that, and I'm smiling silently to myself, because the unfortunate thing is, you know, physical assaults actually take place quite often in the workplace. We've recently had, I've probably chaired two inquiries, and a colleague of mine has chaired another, where employees actually got into physical attacks with each other. Because of a disagreement between the two individuals, it led to physical attacks of each other. But as the inquiry unfolded, what we realized was that actually the more senior person in the scenario was actually bullying the junior person, and that led finally to the junior person acting out, and her way of acting out was actually to physically attack the person bullying her. I won't share too many other details on it, but suffice to say that, you know, like I said, one of the things you need to consider is the context in which it happened. Consider the reasons for why it happened. It does not mean that it's acceptable, but it does place quite an onerous responsibility on the person chairing the inquiry to make sure that, you know, are you considering the factors as indicated in the Act. So let's talk about the employer's obligations. Like I mentioned, you know, when it comes to labor legislation, there's a fair amount of responsibility that is placed on the employer. And in understanding who the employer and what their obligations are, we have to remember how the Act defines who an employee is. Remember, it's not just your employees paid through your payroll. It can be a volunteer. It can be a person who's applied for a position in your organization. What the Act requires of employees is that they must take proactive and remedial steps to prevent all forms of harassment in the workplace. You need to conduct a harassment risk assessment and implement policies and procedures relating to harassment. Now, this for me is quite important. We've recently at HR Talk developed quite a nice, and I think for me, nice is the wrong word, a very effective harassment risk assessment tool. It is a short, sharp, succinct questionnaire that the managers in a business or the leaders in a business have to respond to. And then, you know, based on, we get feedback from them, we analyze the data, we share the feedback with them, but then we take it a step further, because not obviously, in some instances, you know, line managers or leaders in a business would like to think that, you know, they've put all due processes in place, that there are policies in place. But if you talk to the workforce, you may get a different perspective. So the next level then is to say, okay, you know, perhaps we choose a number of employees randomly selected and ask them to complete this risk assessment, this harassment risk assessment. And then we use the data to, you know, to find where are the aspects that we are doing well as an employer, and where are the opportunities for us to get better. The whole intention of the assessment as well is not to, you know, show anybody up or say to the employee, you know, but you haven't done this. It's more to give you guidance and to ensure that you're compliant with the requirements of the Act. And we give you tools and processes to help ensure, and we work with you to give you recommendations on how to make sure that you are compliant. What's equally important is making sure that you do have policies and procedures relating to harassment. The last thing you want to do is, you know, get to a situation where an employee raises an allegation of harassment. There isn't a process or policy in place that guides what needs to happen, how it needs to happen, and who manages the whole process. We do have policies that, you know, we obviously have available, that if you don't have a policy in place, you're more than welcome to give HR Talk a shout and say, we don't have a policy in place. Can you help us put one in place? And then, of course, the Act actually does require, pretty much like with employment equity, where there are specific requirements if you're a designated employer. Likewise, you have to ensure that you have to show that you've done due diligence in making sure that employees are aware of what harassment is, that they are aware of what to do in the case of someone alleging harassment. So conduct training and awareness in the workplace in relation to the harassment is quite important. Designate an individual who is trained to deal with harassment. Now, remember, in instances, it's not an easy thing to deal with. And I think sometimes where we get it wrong as employers is that we assume that if you're a manager, you should automatically know how to manage a case of harassment if an employee brings this forward to you. But that kind of thing is not a given. Not everyone is equipped to be able to handle such situations. So that, you have to ensure that the person is mentally able to manage the harassment allegation brought through, and then assist the employee who alleges the harassment. You have to also ensure that there is counseling, treatment, care, or support programs, and these should be outlined in your policy to say, in the instance of alleged harassment, you can call out some organizations have what they call an employee assistance program, that they can call somebody who is impartial, independent, and unbiased to hear and talk to the person who alleges the harassment. So when harassment has been brought to the attention of the employer, it's important to consult all relevant parties. Now, remember, there's always two sides to the story. And remember, we talked about understanding the context of the allegation and how it arose. So you have to obviously talk to the perpetrator and to the victim to get both sides of the story. Obviously, and I'm maybe stating the obvious here, is that you talk to them separately to get Jenny's perspective versus the person who she alleges the harassment against. And then you need to take necessary steps to address the complainant in accordance with the code or the employer's policy. So if you don't have a policy in place, and if your policy statement is that you will be guided by the Gazette as it relates to the prevention of harassment in the workplace, then that should be stipulated somewhere where employees understand that this is where they can go to understand what needs to happen in the event of me feeling that I was harassed. And then as an employer, you also need to take steps to eliminate the harassment. So in the instance of, like we said, in the instance of an employee alleging sexual harassment, you have to consider suspending the person, because what you don't want to do is having the person who you've alleged the harassment against still being in the same environment with the employee who raised the allegation, because that leads to the hostile environment. Failure to take steps to eliminate harassment once an allegation has been made will render the employer vicariously liable for the conduct of the employee. This is the case even if it is one incident. Remember earlier we spoke about harassment. It can be a single event. It doesn't need to be a sequence of events. So even if it's an allegation of one instance, you have to take measures to ensure that you create a safe environment for your employee who is alleging the harassment. And then we look at your harassment policies. They must substantially comply with the code and include statements listed in the code. Now, when we talk about substantially comply, what we're talking about is obviously the substance of your harassment policy. It has to make mention of, as an example, what is the definition of harassment? What are the different types of harassment? What happens in the event of alleging harassment? What steps are available to you as the victim. I don't like necessarily using the word victim, but the Act does use the word. So what are your steps and what are the avenues available to you to ensure that you can raise it in a safe environment? So that's what we talk about when we say substantively comply with the code. And then you have to be quite explicit in specifying the procedures that must take place where harassment is alleged to have occurred. Like I mentioned, in the case of the teacher raising the harassment allegation against the vice principal, obviously the principal of the school had erred in that he had not suspended the employee against who the harassment was made against. So, in that case, obviously, sorry, I just lost my train of thought. The victim, for want of a better word, the victim had access, or she had as evidence as well, numerous WhatsApp messages from the perpetrator, and where she responded to the perpetrator saying, I am very uncomfortable with this conversation. I don't appreciate this conversation. It's not acceptable. But the perpetrator continued with these WhatsApp messages, etc. And obviously, in a place of work where you in a school environment, right? Or even in a work environment, you spend most of your waking hours in your work environment. So the victim was actually constantly having to see the vice principal, and this made for a very hostile environment. And then, like I mentioned, your policy has to also include what does the victim have, or the employees have, in terms of counseling, treatment, care, support programs. And these don't necessarily need to be expensive or a program where you have to pay huge amounts of money. There are numerous organizations out there who actually offer counseling for free, and because of also the level of GBV that we have in South Africa as well, there are avenues available that you can explore as an employer to say, these are the potential resources that you have access to in the event of you alleging harassment, and that you can speak to somebody openly and freely without feeling intimidated or without feeling fear of being victimized. So there are avenues available to you as an employer that you can investigate. And then, like I said, the Act does require, and in your policy statement, you want to make sure as well that you implement ongoing awareness programs. It's like, with most things that are legislated from an employment perspective, you can't just do one session of training on harassment and assume that, okay, I've done it in January, I don't need to do it for the rest of the year. Maybe, maybe not, depending obviously on the size of your workforce, things like your turnover, etc. But we generally encourage our clients to consider having it, at minimum, at least twice a year. So this way you also get to reach as many employees as possible. Best practice would say, run it once a quarter. It doesn't necessarily have to be a 1 hour session. It could be a quick, short, sharp half-hour session where you're explaining to your employees, what we want you to understand is that this is how harassment is defined in the workplace. These are the different types of harassment that could occur. And in the event of you feeling harassed, these are the measures that we have put in place to ensure that you have a safe working environment. So we encourage that, these are at minimum, these are the things that you can make your employees aware of. And then, of course, the policy must then state is that you take appropriate steps where harassment occurs. Interestingly, the Act also talks about sick leave. The code. The code talks about encouraging employers to provide additional paid sick leave if the complainant has exhausted his or her sick leave where the employee requires trauma counseling. The employee may claim illness benefits via UIF as well. So the code that we've been talking about, obviously, the entire morning, is quite a detailed code. And unlike some of our legislation, it's actually quite easy to read and understand. And the code is quite explicit as well, where it says, that sometimes we may have instances of where an employee has exhausted their sick leave, but they need trauma counseling. As employers, you are encouraged to provide additional sick leave for the individual, and the employee can then claim this back. So as a government, they have also ensured that, if you are giving additional sick leave to the individual, and it would probably be unpaid leave, they can claim that back via UIF. So there are avenues available in terms of how you can support your employees who have exhausted their sick leave. So what are the consequences if we fail to comply? Any employee who feels that he or she has been unfairly discriminated against, or that an employer has contravened the laws, may lodge a grievance in writing with their employer. The matter may thereafter be referred to the CCMA if the issue cannot be resolved at the workplace. So like with any labor dispute, as employees in South Africa, we can go to CCMA and the matter can be heard there. The very same avenue is available to employees as well, is that if the matter remains unresolved internally, the employee can actually refer this to the CCMA. Then, if the CCMA is not able to resolve the dispute through conciliation, the matter can either be referred to arbitration if the employee earns less than the amount set by the Minister of Employment and Labour, and it gives you this detail in terms of Section 6.3 of the Basic Conditions of Employment Act. If the employee earns above the amount referred to in the basic conditions, the matter may be adjudicated by the Labour Court. So now we've got guidelines that say if you earn less than X amount, you can go to the CCMA. Go through conciliation, or you can continue with arbitration. If you earn above a certain threshold, you now refer the matter to Labour Court. What we need to remember, though, is in these circumstances, if both parties agree in writing, the matter can be arbitrated by the CCMA. So even though you may earn above the threshold, as cited in Section 6.3 of the Basic Conditions, if both parties agree, right, the perpetrator and the victim agree that they will try to settle it at CCMA, that it is arbitrated, not conciliated, that is arbitrated at CCMA, then that is an avenue available as well. However, should the victim not feel comfortable with this process and they earn above the threshold, they then have the avenue of referring the matter to the Labour Court. It's important to know that in sexual harassment matters, the employee has a choice between arbitration at the CCMA and adjudication at the Labour Court, regardless of how much he or she earns. Now, we just literally spoke 2 seconds ago about thresholds that apply to when you take the matter to CCMA, but in cases of sexual harassment, you can go directly to the Labour Court, irrespective of your earnings as an employee. I'm looking at the time and I realized that I either spoke really fast or it was a shorter webinar than usual, because the next thing we ask is, are there any questions? I think what's important for me to reiterate is that, when you're trying to define what is harassment, and I find that this line captures it for me, is that if it's unwanted, it's harassment. If the person has told you, like we said, either verbally, directly, or indirectly, it's unwanted, then it is harassment. So, it's also important to understand what measures you put in place to ascertain if it is harassment. That being said, I'm just going to quickly pop into the chat box to see if there are any questions. Are there any questions online? Thank you, Jan. I appreciate your feedback. Are there any questions? Was I that clear with explaining how this needs to be managed? Please feel free to pop your question in the chat function. I'll stay on the line for a few more minutes, and just to remind you that if as an employer you don't have a policy in place, I encourage you to put a policy in place. If as an employer you need to investigate or source mechanisms or providers who can provide counseling, you're more than welcome to give HR Talk a call, and we can refer you to a few of the providers that we have in our database. And if you need support with any, if you need to do a risk assessment, a harassment risk assessment, we also, like I said, we have a tool in place that we've been using with clients. They found it really useful. We are currently implementing plans for a couple of our clients where, based on the feedback that we've received from the harassment assessment, we've put measures in place to ensure that they are compliant as per the regulation of the code. Thank you, Mbongeni, that you say it's clear and well understood. Sometimes I like to think that, if you present well and you're clear and articulate about what you're saying, there generally wouldn't be questions. But then the other side of me says, but Jenny, there should be at least one question. But I will take Mbongiseni's comment and say that it was clear and it was understood. Okay, there is a question that says, if a false accusation is made, who is the victim and what recourse do they have? Great question. So there is in the policy, in our harassment policy, and it actually is in the code itself, is that it explicitly states that if there is an untrue allegation made, the person who raised the allegation, okay, in this instance is the victim for now. When the victim raised the allegation against the perpetrator, and upon investigation, it was actually found that the victim had lied about it, the company actually has the right, and the perpetrator has a right to actually take disciplinary action against the victim, because you are obviously, the allegation of harassment is a serious thing and we don't take it lightly. So there are avenues available and the victim can face disciplinary action. And this is quite explicit in the policies that we have in place as well. Sepo says, please share the organizations you talk about which offer counseling for free. Sepo, what I will do is, I know that once we finish the webinar, you get a copy of the recording, etc. I will make sure that on that email, we give you access to organizations that you can contact with their contact numbers, so that everybody who is on this webinar will have access to it. Definitely will do that. I'm not sure if you were able to hear my answer from CT about the false accusation. Lizelle asks a similar question. It says, sorry, I think you've got to say it loud. If there is an accusation made, do you suspend both the victim and the perpetrator, or do you just suspend the person whom the allegation is against? Excellent question, Lizelle. So remember, in the way the code guides you is that we're saying, so should Jenny raise a grievance against, I'm going to use my colleague's name, sorry, Sabelo, but if Jenny raises an allegation against Sabelo, obviously the process is important in that, remember we said we gather information from both sides of both parties, so from the perpetrator and from the victim. And if we, at that point, Lizelle, if we're unsure, and maybe we need to continue the investigation, right? So if at that point we are unsure who is telling the truth, we can suspend both employees. But if you find that, as an example, when Jenny raised the allegation against Sabelo, she had a whole list or a whole pack of evidence. There was WhatsApp messages, there were videos, there were conversations that were recorded, there were emails, and the evidence is overwhelming. In that case, you would suspend the perpetrator only, and then obviously set an inquiry as soon as possible. So I hope that answers your question, Lizelle. And remember, like I said, what we have to understand is that we have to apply our minds in these instances, and it's not always easy to make that call. But in a case where we're unsure about what should we do, who's telling the truth in this instance, the safer bet then is to suspend both employees. Obviously, the unfortunate thing with that is that when you suspend, legislatively, you cannot suspend without pay. So it obviously will come at a cost to the organization. That being said, though, is that it's another reason for why you want to make sure that when this goes to an inquiry, you do so as soon as possible. There's something in the Act that I would like to also just mention, which talks about, the timing in terms of when an allegation is brought to the attention of the employer. Now, it talks about during in a reasonable period of time. And one of the reasons why this was built into the code is because you need to understand that, in some instances, depending on what the type of harassment is, you could find that the person is feeling extremely traumatized. So you have to allow the person, so they may not necessarily be able to come or feel confident enough and comfortable enough to report it immediately. They may take a day, they may take a week, but you have to consider what were the circumstances and the extent of the harassment before you say, well, you didn't tell me about it at the time it actually happened. So you've got to actually apply your mind in that instance. I hope that helps you understand that a little bit better as well, as Lizelle. Bui says, may you please elaborate on the part where one needs to include principles of the new code in the harassment policy? What do you need to include? Bui, that's quite a long question. So if I look, and I've got the code right here in front of me. If the code itself is 30 pages long, but basically what we've done, and I'm just thinking of the policy that we've done based on all of the information in the code, is we've developed obviously a harassment in the workplace policy, and it needs to include things like I mentioned, what is the definition of harassment? What are the types of harassment? What happens in the instance of harassment being brought to the attention of the employer? It talks about procedurally, how is the matter dealt with? Is it raised through a grievance process? What is your grievance process? If it's not resolved internally, can you appeal the situation? So you have to align your policy to the requirements of the code. And even if you look at the table of contents on page 2 of the code, you can use that as a guide in terms of what needs to go into your policy as well. If you don't have the authority to say to HR Talk, we would like to purchase your harassment policy. But I would suggest that if that is the case, then you look at the code itself. It's a government gazette that was issued on the 18th of March 2022, and the table of contents is a good indicator of what you should have in your policy. I hope that helps answer your question. You're welcome, Lizelle. I'm just looking on the chat function if there's anything further. We've got 20 minutes more. I'm not going to keep you for 20 minutes, but if there are more questions, I'm happy to try and answer them to the best of my ability. Bui, I hope that that answered your question. You're most welcome, Bui. And I'm just looking at this, Bui, whilst, like I said, I've got the code right here in front of me. It even talks about, and it explicitly states, additional sick leave, how that is managed, etc. So I find that the code is, like I said, it's one of the more easier documents to read. So you'll be able to use this as quite a nice guide to develop a policy if you don't have one. You're most welcome, CT. Just want to share, if you haven't seen in the chat, it says, please note that all notes and webinar recordings will be uploaded onto HR Talk website as soon as they are ready. An email will be sent to all attendees with all the appropriate links. Just to reinforce the point that, or the question that Sepo says, please can you give us information about companies that offer counseling for free? Okay, I see most of our participants have dialed off. For those of you who are still on the call, thank you so much for participating. I really enjoyed presenting this. And if you need, you're most welcome to Bile. Bile says, thank you for the informative session. You are most welcome to, if you're feeling a little overwhelmed or you need support or guidance regarding the code, please feel free to reach out to HR Talk. As indicated, you will receive an email with our contact details on it, and we will support you as best as we possibly can. So thank you again for joining, and I hope you have a great day further. Please be safe. Thank you so much.